Hello, everyone. Welcome to Talking Legal with Templars. I am Ijeoma Uju, a partner with corporate and commercial practice at Templars. Today's episode is significant because it happens to be our very first Talking Legal regulatory edition. To launch this episode, I have with me today none other than the Registrar-General of the Corporate Affairs Commission, Mr. Hussaini Ishaq Magaji, Senior Advocate of Nigeria. You're welcome, sir.
Thank you very much. Thank you for having me.
Sir, it's been a little over 9 months since you assumed office as the Registrar-General of the Commission, prior to which we had a significant milestone of the amendment of the Company and Allied Matters Act 2020, which introduced really good ease of doing business reforms, which included electronic share transfers, electronic payments by companies, and we now even have virtual general meetings. One really innovative reform that was very welcome was the introduction of the company's registration portal, the CRP, which really has eased and really reduced the timelines that typically would have affected a lot of companies doing business in Nigeria.
Yes.
So since your appointment, have there been any notable highlights that you would like to share with us?
Yeah, of course. Upon assumption on duty, we realized the existence of the law. Most of the law, they are not put in effect. What I mean, we pick interest on enforcement of compliance of the provisions of the Company and Allied Matters Act. For instance, I initiated issue of formalization of entire businesses in Nigeria, of which I started with the fintech industry. Fintech, that's where the agent banking system is thriving in Nigeria. Agent banking is been in existence as a regulation in the CBN, Central Bank of Nigeria, since 2013. And you are aware of the existence of POS all over Nigeria now. So that's where they are driving their potency from the CBN. The CBN, they are giving license for that kind of operations, and they've been doing that kind of business without registration. So if you go back to the Company and Allied Matters Act, specifically Section 863, subsection 1 now, it makes it mandatory for any person doing any business in Nigeria, whatever kind of the business, he must have his business registered with the Corporate Affairs Commission. And they've been doing this business without registration. This is one of the areas where I pick interest. I ensure that any person in that industry must comply with the provision of the law. I moved CBN. Finally, the CBN made it a mandatory for all the MMOs. MMOs mean mobile money operators, to ensure their subscribers or their customers have themselves registered with the Corporate Affairs Commission as a business names. And they have class, the class of business, the class of businesses thriving in that industry are 3. They have what they call agent, they have what they call super agent, and they have what they call merchants. These are the class of businesses recognized by that agent banking regulation 2013 at the Central Bank of Nigeria. And if you go back to that agent banking regulation 2013, it's emphasized that for you to be eligible to have a terminal or POS in Nigeria, you must be an entity. And they have not been implementing, they have not been doing anything now until when I come on board now, coupled with the provision of the Company and Allied Matters Act, which made it mandatory for any person to do any business must be registered in Nigeria. And where we are now, we are targeting to formalize over 20 million businesses in Nigeria. This is one of the achievements. Now, another thing now we are doing now, we have understanding of bringing LEI, legal entity identifier. This legal entity identifier now, it is a global practice now that you can't do any business across the border without that legal entity identifier. It's like your international passport. You can't go to another country without that passport. The legal entity identifier, when it's finally come on board in Nigeria, you don't need KYC anymore. Okay. Once a person introduces himself to do business with you, if you give you that 20 digit or 20 digits, once you put that digit, it will give you the actual structure of that company. It will give you the trend, the status report and everything, their update and everything, anywhere you go. So no one will now ask you a paper, give me your certificate so that we'll verify, give us our from CAC7, give us this thing will do away. So in the UK now, like Bank of England now, they have issued a statement now that from September, some kind of transactions now you can't do it without LEI. So here in Nigeria now, CAC, we are making effort to see that we're being recognized as LOU. LOU, we are going to be the issuer of the LEI. That's local organizing unit, that's LOU. So we are making effort to see now Corporate Affairs Commission sitting or hosting the data of the country now. We are now be giving the LEI direct instead of allowing private companies to come and have access to private people's data. So CAC now will now be an LOU, as happened in France and Italy. This is another innovation that we are going to see how we can go on it. This is all part of my highlights so far at the Corporate Affairs Commission.
Thank you so much, sir.
Thank you.
Have been very busy this past few months. As you can imagine, as we have you in the room, we have quite a number of questions that some of our clients have been concerned about. But before I go into that, I just want a quick clarification from you regarding the issue of minimum paid up share capital by companies with foreign participation. So sometime last year, the Commission issued a public notice that required companies with foreign participation to have a minimum paid up share capital of 100 million naira. And the affected companies that did not have this 100 million needed to increase their share capital. But subsequently, the Commission issued another notice saying that the public should disregard the initial notice and that an amended notice was going to be issued. But the CAC has already gone on to implement the requirements, and we even know that existing companies are not allowed to file if they have not met this requirement, and new companies will not be registered. So, sir, what exactly is the current stance of the CAC with regard to companies with foreign participation? What is the minimum required share capital, and should we expect a further notice to clarify this position?
Yes. Sometime last year, precisely on 5th December 2023, by way of public notice, we made announcement that companies with foreign participation, the minimum share capital is 100 million paid up capital. And 3 days after, precisely on 8th December 2023, we made another announcement reviewing our earlier position on that. And that position, we made the publication pursuant to existing policy at the Ministry of Interior, where it stated in their handbook that no company should do any business in Nigeria with a foreign participation without evidence of 100 million naira paid up capital. And we, after study, then we now realize that our Company and Allied Matters Act, it's been consistent on the issue of share capital. The share capital of companies, it's been consistent in the Company and Allied Matters Act to be issued share capital. That's the reason why if you go back to the notice, you now see that, yes, we have reviewed our stand, withdraw the issue of evidence of 100 million naira share capital, paid up capital to the issued share capital. And also, in our earlier position, we made people to understand that if you are existing company, they have 6-month period to comply with that, our policy, new policy. And for the new companies, it is immediately now. So because of plead of the stakeholders and the concern of the private group of private investors showing that it's additional burden to the system, and for ease of doing business, we consider reviewing the policy. So we now stick to the position of the law that banking on our provisions, precisely Section 8, subsection 1E of the Company and Allied Matters Act, which gave us, which gave us opportunity to recognize any existing law or policy by any government agencies. We now recognize or implement the position, forwarded by the Ministry of Interior, that any company with a foreign participation, the minimum share capital, but we situated our position in line of the Company and Allied Matters Act. That is, we now make it that issued share capital should be the benchmark or the basis for the judgment. So henceforth now, we are now implementing it that any new incorporation coming or any new activity coming to the company now, if it has a foreign participation, so we recognize the 100 million issued share capital. That's our position.
Thank you very much, sir, for that clarification. So hearing from you as the head of the commission, I guess no further notice is required. We've seen a wave of recapitalization in these past few months from different regulators across sectors. It started with NICOM, the insurance regulator, directing insurance companies to recapitalize. And then we have the Central Bank of Nigeria, which has directed banks to recapitalize. Also, there was some guideline also issued for Bureau de Change operators, the BDCs, which may effectively result in the BDCs having to merge or acquisitions taking place or even recapitalizations. So there has been this wave going on. And I know the CAC just last week actually issued guidelines for banks and other financial institutions on the recapitalization exercise. This is going to see significant traffic at the commission. So I wanted to know, going forward, this person's planning to recapitalize, what should they take note of? How is the CAC getting prepared for them? And for some of these people that will be doing these capital raises through public offerings that require the approval of the SEC, and where you also have the to invite the public. Some of these persons will go beyond the 15-day window that is required for the allotment. How does the CAC plan to deal with this? Will waivers be given to these companies?
Okay. My response on this very question now, to underscore the importance given to it by the Corporate Affairs Commission, we constituted a committee chaired by the Registrar-General of the Commission, that's me, to ensure that banks have a seamless transaction with the Corporate Affairs Commission. As you rightly mentioned, we came up with a guideline, and the guideline can be obtained in our website, www.cac.gov.ng. And here, we also provided an email, dedicated email, bank recapitalization at cac.gov.ng. That email certainly is to ensure that all the applicants to the Corporate Affairs Commission or whatever class of capitalization options have access to the CAC seamlessly. Of course, we're aware that we may experience or we may receive issue of application for mergers, application of increase, or application of even downgrading of the size of the bank. So all in all, the CAC role is to register the share capital, even though we have a handshake with the Security and Exchange Commission, where saddled with this organization is saddled with the responsibility of registering this order. That's a sectorial regulation as far as the issue of shares is concerned in Nigeria. So we have understanding doing this thing together with the Security and Exchange Commission, but Corporate Affairs Commission, our own, is to ensure that this issue has a hitch-free exercise. And I'm telling you now, with the structure put in place now for this recapitalization, banks, any bank approach the CAC can achieve any transaction we want to achieve with CAC within 24 hours, barring any queries or improper submission of documents.
Now, something that also just happened recently, the recent decision of the Federal High Court with regards to Section 18 subsection 2. And it validating the single shareholding status even for companies that were pre the CAMA 2020. A lot of companies are having a huge sigh of relief because most of the, not most, I mean, there have been companies that were pre-CAMA 2020 that want to restructure to single shareholding companies, but the Commission has not granted this. So this decision has come as is welcome to most of them.
Okay.
And they are going to take advantage of it. So is the Commission going to appeal? And if the Commission is not going to appeal, when should we expect implementation?
From my own perception or from the corporate affairs perception, certainly we are going to appeal that judgment. Because our own perception, the Corporate Affairs Commission on this thing, Section 18, subsection 2, comes, to bring the issue of a formation and incorporations. It's not talking about the existing companies. It's talking about the companies coming on board, new incorporation, new formation. It's like, to us, our perception is like that provision of the law. That provision of the law is talking about the one-man company where a company can have a single shareholder or can have a single director in the company. That's the innovation. So this is the basis why we are going to appeal this judgment, certainly. But I'm still waiting to have the full copy of the certified copy of the judgment to review and see how do we going to take this thing up. And we must take it to the logical conclusion.
I guess we'll have to wait and see the appeal and the basis on which the appeal will be done, because what is being said is that Section 18 is clear. It does not give any exceptions and it doesn't give any restrictions. What Section 18.2 says is that you can have a single shareholder company. It did not give a restriction whether it was prior to the act or post the act.
But the section our understanding here is not conferring substantive right to the companies prior to 2020, CAMA 2020. What I mean saying that it doesn't, the draftsman, by the letters of that provision, doesn't mean that, trying to make it to have retrospective effect or retrospective rights. What I mean retrospective right, even though I'm aware, issue of implementing law retrospectively is centered on criminal cases. I have my reasons for saying that in a lot of Supreme cases now, they are now trying to confine it within the criminal jurisdiction. But what we are saying now, it doesn't give a retrospective right for companies existing prior to CAMA 2020. But what we are saying, it comes at, CAMA, brought additional option. It brought additional option to investors that you can either company have a traditional arrangement of 2 or more directors, or you can be a single director. If you have staying as a single director or a single shareholder, of course, you have the opportunity of not having a meetings. You have the opportunity of doing some other things. But if you are 2 or more, certainly you must go by this. Each provision of the CAMA has reasons for its existence in the Company and Allied Matters Act. And we must guard. I'm going to protect the provisions of the law. I'm taking it up.
Thank you, sir. We'll look forward to seeing what the appeal is. So in the last couple of years, the CAC has dispensed with giving piecemeal documents, like when companies require evidence of filings, the certified true copies that used to be the norm. So what now we get from the Commission are status reports, which have actually been very helpful in providing useful information on companies. But sometimes these status reports come with errors.
Okay,
And
online?
yes, online requests.
Okay.
So they come with errors. We know that, yes, the CJC has embraced the digital transformation, but frequently we see errors in these status reports. And we wanted to know if there's something that companies can do to help to, eliminate these errors. And also, the status reports, though very helpful, we wanted to know if the CAC is also considering more categories of information. So for instance, when you get a status report, you won't get information on whether there's existing charges or debenture.
Okay.
Also information as to whether that company is being wound up. Would the CAC consider putting this information in there? Want to know, has a resolution been filed for the winding up of this company?
Okay.
Want to know if a receiver has been appointed for this company. So want to know if the CAC will consider putting in more categories. All of this is actually part of the ease of doing business and to eliminate people coming to get those kind of information piecemeal.
Okay, that is one of the challenges and inherited in the system. And we're doing everything humanly possible to ensure that we make it seamless to our customers. Actually, it is the problem has been identified that our automation, now we CSU migrated to fully automation in the year 2021. So we still have some challenges in the post-incorporation activities. At least when I came on board, I discovered that there are like about not more than 34 entries or activity or post-incorporated activities now embedded in the company registration portal. And from the review of the Company and Allied Matters Act, we identify more than 84 entries ought to be part of the post-incorporation activities. So everything, goes to the level of how the CRP has been designed. So these are the issues that now I'm doing. I think we have 60%, to completion, ensure that everything now, our CRP now, operates optimally, in line of the best international practice to ensure all these things that you have mentioned now, that you will not, if you come back now, next time now, I don't know when you are coming back, I believe that you will not put this kind of question to me now because it's something that has to be addressed. I take it serious.
Also tied to that, we also want to know if the Commission will also begin to allow the filing of miscellaneous items, because we have some transactions that we want to file some miscellaneous items, maybe on some security interests.
Yes.
And there is no allowance for that, also with this, because of this digital transformation. But sometimes some companies, especially where you're doing due diligence checks, KYC checks, they also want to know this information. So we want to know if the CAC has considered all those miscellaneous filings for these companies.
Yes, we run we are creation of law and we run our operations by the letters of the law, either our regulation, company and matters, or this thing. That's the reason why we are improving our law. If you now check my table now, I have our company regulations, company and allied matters, our person with significant control, and our, bank insolvency, something like this now. Just for me now studying how we can improve our regulation now so that we can have 2025 regulation, 2024 regulation. This is one of the areas that if you see it necessary, is certainly going to be incorporated in the new regulations so that we have opportunity to carry out in our company registration portal.
Thank you very much, sir. And on this note, I would like to say thank you to everyone for joining us on our very first Talking Legal Regulatory edition. You can be sure that we would have subsequent editions, and we look forward to seeing you then. Thank you.